Okay, well, let's go ahead and get started with our second panel, and thank you for being here. And we have big shoes to fill after that excellent opening panel, but we're all very pleased to be here and looking forward to discussing this next issue. My name is Tom Williams. I'm an attorney in Fort Worth and a board member of the Freedom of Information Foundation. And in that capacity, I echo Jim Hempel's and Aris welcome and thanking you for being here. In case anyone is interested, my date of birth is December 19th, and you've got, 3 months now to go out shopping for me, and I will expect to hear from everyone, so thank you for that. Let me first introduce our panelists and then talk a little bit about what we're gonna do in the next hour and 15 minutes. And I will just introduce our panelists in the order they are sitting up here. We have had a couple of changes from what's in your program, and we'll talk about that when we get there. So, beginning at my immediate right is Josh Hinkle. Josh is with television station KXAN here in Austin, where he is the Director of Investigations and Innovation. He also leads the station's political coverage, and especially relevant to what we're going to be talking about today. In the last year or so, he and a team of others from the station produced a series concerning the issue of police transparency generally, but specifically as it pertains to the situation in which there is a death of someone in the custody of law enforcement. And in fact, that series is, just to give you a sneak preview of lunch, that series was very deservedly won one of the Gavel Awards that we're going to see presented at lunch after this session. Josh got his undergraduate degree at Oklahoma State University. I don't know where he's tailgating tomorrow, but that's a different issue. And his Master's of Journalism at the University of Missouri. Our next two panelists, I'll introduce sort of together. Kathy and Robert Dyer, they are from Paris, Texas, not France, and we're glad to have them both here. Kathy Dyer is a civil engineer by trade and is retired from a long career with TxDOT. So if you have highway construction in your way on the way home, you no longer can blame her, but I'm sure there was a time when all your friends were happy to complain to you about orange barrels. And Robert Dyer is retired from a long career as a science teacher in the public schools. There was an incident as your program says, in 2013, in which their son died in the custody of law enforcement, and as a result of that personal experience, they've become interested in this issue and have spoken on it and have been involved in some things they're going to talk to us about. The next two panelists are not shown in your program. Andre Segura from the American Civil Liberties Union of Texas, like unfortunately a lot of other people from Houston who are not here today, was interrupted by Imelda, and he could not get here last night. But here from the ACLU and its Texas office is Matt Simpson. Now, Matt works in the organization's Austin office, which happily is right across the street, so we were confident he could get here. And Matt, we appreciate you doing it and being here. He is the Deputy Political Director of the ACLU of Texas. He got his undergraduate degree from Baylor and his law degree from Lewis and Clark. And he does a lot of the organization's legislative work, in fact, spearheads it, and in the course of that, naturally, given the organization's focus, he works on a variety of criminal justice issues, including the one we're going to talk about today. Troy Gay from the Austin Police Department also could not be here today, but from the department is our final panelist, Farah Muscadin. She is the director of the Office of Police Oversight with the Austin Police Department, and that's a newly established position. Prior to creating that position, she served as police monitor, as the police monitor for the Office of the Police Monitor for the city of Austin. Before moving down here, she worked in Chicago in a variety of legislative and legal positions, including the Public Defender's Office. She is a graduate of the University of Iowa and the University of Iowa Law School, and is currently co-chair of the YWCA Greater Austin Board of Directors. So thank you to all of you for being here today. Just to kind of set the stage a little bit before I turn it over to our panelists, the specific issue in the Public Information Act that we are primarily going to focus on today is an exception to disclosure that we find in Section 108 or 552-108 of the Government Code, if you want to be a nerd and have the full site. And it goes back to something that came up actually in the 1990s under a prior version of the statute, in which the Attorney General's office and courts had some issues dealing with, well, how do we handle the transparency or lack thereof of closed police files? So there's an arrest or something of that nature. The case is closed. What happens then? And if you really want to go back into the early 90s, like Chairman Hunter was talking about in the first panel, under a different wording of the law, there were Attorney General opinions that said, well, if information in the closed file might nevertheless have an adverse effect on open cases if released, then maybe it can be withheld, and so on and so forth. Well, the legislature came in and amended the statute, and this is language we've actually had now for quite some time, but it provides an exception to disclosure for information dealing with the detection, investigation, or prosecution of crime on a closed file if it relates to an investigation that did not result in conviction or deferred adjudication, okay? So it doesn't talk about what it did do, it says if it did not result in conviction or deferred adjudication. So obviously one example is there's an acquittal, or maybe there's no charge ever filed in the first place. The person's arrested, well, didn't really do anything, or let them go, or perhaps even it goes all the way, there's a trial and an acquittal. Well, that case did not result in a conviction or deferred adjudication, and that's probably the most common situation. But another way in which a file can not result in conviction or deferred adjudication is if the person arrested or a suspect, or that's mainly what we're interested in this panel, if a person arrested or a suspect dies before the case is concluded, and perhaps even dies while in police custody. Well, that case did not result in a conviction or deferred adjudication, obviously, and so the language of the exception still applies. Josh, as I said, you in your station did quite a bit of reporting on this issue, looked at some specific cases, and how this section of the law is applied in practice. Tell us kind of what you found.
Yeah, this all started with our station back in January of 2017. There was a breaking news situation that happened just a few blocks from here where a young man was arrested for shoplifting at a local mall. And on the way down to be booked at the police station, he had managed to hide a gun under his waistband and pulled it out and wriggled his hands around to the front and shot himself in the head. And this played out as breaking news, and it went through the entire police investigation and eventually was closed. So we wanted to know more information about this case, how that was possible, how that even happened, why they missed the gun, that kind of thing. So when we started requesting information, the city of Austin and Austin Police denied us a lot of information that we were hoping to get. That would have shed some light on this issue, and they cited the law that Tom mentioned, and I had never heard of this before, really, because most often when we're dealing with the police case. It's about an open investigation, and that's the reason that the information was being withheld, because we don't want to jeopardize an ongoing investigation. But because this was closed, I wondered, is this unique? Is Austin doing something that is not done very much? So we started looking into it and found that it's not really tracked. And so we had to go agency by agency to figure this out. And it was very challenging because of several steps that took us down this long path to realize that it's happening in many agencies across the state, and they're able to withhold information like this and not let people know exactly what's happening when someone dies in their custody. We looked at just 21 of the largest agencies in the state and found over just a 2-year period that there were 150 times in 52 deaths that this was happening. And that's just 21 agencies in 2 years. There are more than 3,000 law enforcement agencies in the state, and this exception has existed for 2 decades. They don't have to keep the records that long, so it's impossible to know how often it has been going on. And the Attorney General doesn't even track this, and that became very, very difficult. So that's why we decided to go down this road to do an entire series about this open records loophole. And we got to meet some a lot of lawyers, a lot of journalists that were going through this, but a lot of families that were also going through this exact thing, just wanted to know what happened to their child. Why did their child die in custody? And that's how I met the Dyers, and they were very nice to open up their home and let us come in and tell their stories, among other stories, and I guess that's kind of an introduction for them, right?
All right, that is a good introduction for Mr. and Mrs. Dyer, and they've been very forthright about discussing their personal experiences, and we're glad to have them here today. I think Mr. Dyer, you're going to go first, and
good morning. I'll start off with I'm honored to be here, and I might start crying, but on Tuesday night of 12th of August 2013, we got that most dreaded phone call that any parent could want to get, and it came at 3 o'clock in the morning, and it was a person from the Mesquite Police Department said that our son was severely injured, and he had gotten in some trouble, and he was at the Baylor Hospital. And so it's about a 2-hour drive for us, and we hopped in the car and beat feet down to Dallas, pulled into the emergency room, kind of really not knowing where to go, and then we noticed there was a hospital administrator met us at the emergency room and informed us that our son was gravely injured, possibly might not survive, and that he was still under arrest. And he was up in the ICU, and so we went up to the 4th floor and got off the elevator, and there's about 4 or 5 police officers around there on the floor, and even to the point that they guarded the ICU and wouldn't even let us in to see our son in the state he was in. One thing that I noticed, we had to wait several hours for several things, and like I said, there was a policeman outside the door of the ICU, and then one actually in the ICU itself, watching what was going on. And there was another officer kind of going back and forth to the others, and had a jacket that said CLEAT, C-L-E-A-T. And it's, I found out later that that's their lobby or lawyer group or whatever. But they wouldn't let us go in to see our son until it was, what?
9 o'clock.
9 o'clock in the morning
4 hours after we
4
got
hours after we got there, when they hauled him down to do a CAT scan, and I guess at that point they realized that his brain was shutting down. And then they left, and then we were able to go into the room. And then they talked to us, said that our son had bitten a police officer, so he was under arrest for attack on an officer. And that they had already gotten into his telephone and on his Facebook, and if you know anything about teenagers, they said there was all kind of incriminating information about him and telling us how bad a kid our son was. We went home, and they contacted us again and said, if you want to come down to the police station, we'll talk about all this stuff and go over what all happened. And it's like, this was right before our funeral, and we just, weren't in much shape to go down and do that. So after that, we just, wanted to find out what happened. What was going through my mind was, well, if they arrested him, then they had to book him in jail, and there ought to be a mugshot of him standing in, what kind of condition was my son in when you booked him into jail? And we contacted a local lawyer there in Paris to kind of go. We knew there was videotapes, and I didn't particularly want to see them, but I wanted a representative of the family to at least, see what actually happened. And the city of Mesquite wrote us a letter, basically.
They didn't write us a letter.
Well, they responded back that they did not have to release any records at all, and they cited this 108 clause. And we were foundering, there for a little short bit. I thought, well, okay, if somebody dies in police custody, then the Texas Rangers come in and figure out what went wrong, and they did. But they found that the city of Mesquite, as far as they could tell, followed all whatever procedures that they had, and so I guess that was supposed to let us, leave us there. And we tried several different things, and eventually we contacted the FBI to look into it. If the city of Mesquite didn't help us and the state of Texas didn't help us, then maybe the federal government might have something. And so the FBI looked into it and got all the records, and then there was nothing that they could do about it. And so that's kind of where we were. But then I remembered, well, there is a Freedom of Information Act that you can get records in the federal system. And so we filed a request through the Freedom of Information Act, and after a pretty lengthy process, we finally got the records. It was about 2 years from when this incident happened till till we got it and instigated a lawsuit against the city of Mesquite, and oh boy, and, you know, and to do something like that, you have to attribute a very specific act to a very specific person. Well, if you don't know anything, you can't do that. And so we were kind of hamstrung all along from the very get-go. And then the 2 years passed. There was, you know, it passed the statute of limitations for the district attorney of Dallas to do anything about that. Later on, I found out why they didn't want us to know what happened to our son. There's probably a very brief 1 or 2 minute window when all the officers responded and they had an EMT. They could have easily just stuck him on a stretcher and taken him to the hospital, and he had taken a pretty large dose of LSD and was going all out of his head. But they chose to take him to the police station, and he was thrashing around inside the car and suffered severe brain injury. When they first clamped down, you know, you would think somebody dies in the hands of the police, maybe if not at the hands of the police, but definitely in the hands of the police, you'd want to fling the records open. How did this happen? Is there any way that we could prevent this from happening? It was very needless. But law enforcement has a very, very, very large lobby. And we have come up against that a couple of times, and I have utmost respect for Representative Joe Moody, Representative Hunter, and Senator Watson. We tried to get this clause changed in the 85th session, and that just did not go anywhere. And then we came back again last year, and it got a little bit closer. It actually, I think, got to the point that the governor, who was the attorney general at the time that this happened, but it did land on his desk, and I just, they say the squeaky wheel gets greased, and that is very true.
Okay.
Yeah, that's start.
Well, so Robert told you more than I thought he would, but I can always add to what he said. I think you gathered from what he said that our entire experience with law enforcement has been a very negative one. And I'll clarify some things. I'm going to try and stick to my notes. That's probably the best thing. But it's a long story. He's told you some of it. I mean, there's so many details of what our lives have been like since that night. You know, I'd like to share every bit of it so that you could understand what it's like to be in our shoes. But I can't do that. So I want to point out some things that I think are important. As Robert said, we didn't get a lot of information from the police. They told us at the hospital, first of all, that our son was under arrest and would be facing felony charges if he made it. And therefore we couldn't visit with him because he was essentially in custody. That makes no sense because he was on respirator, he was completely unconscious, but he wasn't running out of that place for sure. And then a voice message on my phone from their investigator, Mesquite Police, investigating themselves, that we could come after we did what we need to do, I think is the way he put it. In other words, after we got our son buried, we could come to the police station and sit and view all the video we wanted to see. But he didn't recommend it. And you might suppose that we did not want to see any video. We just want to know what happened. That led us to an attorney because I didn't have any friends or family that I wanted to send to the police station to ask them to watch what we didn't want to see and come back and tell us what they saw. The only thing I could do, was to go to an attorney, and the attorney that we went to was a family friend, so it was kind of like asking a friend, but it wasn't a close friend of ours, so I felt a little better about that, and I guess that's what attorneys sometimes have to do anyway, so you know, my point is we just want to know what happened to our son. Now, because of the way things had unfolded, we do have a lawsuit that's still pending, but that was really never an intention, anything we did intentionally. I mean, of course, we authorized it, but at the time the lawsuit was filed, the statute of limitations was about to expire. And nothing had been done. Well, Mesquite police investigated themselves and found no wrongdoing, as far as we know. They never contacted us again. In fact, when I did call back after our attorney, not our attorney really, but our friend said, well, you know, we asked and they're not releasing any records. And I'm like, how can they do that? I'm his mom, you know. He said, well, they can do it. And so after we got that news, I did eventually, you know, get the composure, the nerve to call back to the detective who'd called and say, you know, we want to come in. And I figured we'd find somebody to go and, you know, help us through that process. And he said, well, we're investigating now. And so all the records are closed. So no, we never did have that opportunity really to view records. We've got this big investigation going on, and we're thinking about whether to file charges against some of his friends that were involved and so forth. And we're consulting with the district attorney's office and so forth. So, okay, thank you. And so for that reason, we thought we'd find another attorney that maybe was more familiar with those types of cases and maybe, you know, could get records that way. As it turns out, that attorney couldn't get any records either, and explained a little more in depth to us that, that's just the way it is with law enforcement. You just can't get much out of them unless they want you to have it. So we went on our way, and as Robert said, we filed a complaint with the FBI, and I got back in touch with that attorney and said, oh, by the way, we've filed a complaint with the FBI. And she says, well, great, if you learn anything, let me know, and we'll see what we can do. So and then his bright idea to file through the Freedom of Information Act with through the federal channel to get records. So I called her again and I said, well, we've requested records through the Freedom of Information Act. She said, well, great, if you can find out, if you get anything from them, well, get back with me and let me know. So when I got contacted that, yes, we will give you the records, but we need time, we need to redact all the videos and all the documents. So it will be some time in, forthcoming, and I let the attorney know that, and she says, okay. Well, in the meantime, she had talked to a few people and was feeling that things were really not adding up in Graham's case. And so she suggested to file the lawsuit because the statute was about to expire, and we didn't know what we were going to find. We knew that nothing had happened as far as anybody telling us anything more than they did at the hospital, nobody contacted us. So anyway, that's how we ended up in a lawsuit. But because you can't get information. So I want to tell you about someone not here today, but played an important role. And that's Eric Dexheimer. Before our paths crossed with Eric's, we were just another family without a voice. Another family without a voice. When the custodial death report database, the Attorney General's database, was made public in December 2016, that's more than 3 years after Graham's death, Eric began to comb through the database, and somehow out of more than 5,000 people listed in the custodial death report database, Eric noticed Graham Dyer. There's power in a name. Eric got in touch with us, came to our home in Lamar County, and spent several hours talking with us about Graham's death, as Josh also did later. And on April the 23rd in 2017, his story was published on the front page of the Austin American-Statesman. And it was reprinted, in part, in newspapers across the country. But perhaps even more significant is that it was shared extensively on social media, though sometimes only the violent video clip was shared. But as I followed the shares on Facebook, I began to see other similar stories. Not just the big stories that had broken, seems like after Graham died, everything in the news was about police misconduct and brutality. There was, one after another. And I can't even hardly remember all the names now, but not just those big stories. On Facebook, I began to see many, many, many other stories of in-custody deaths, day after day after day. And although the details of each death obviously we're different, there's some things that seem shockingly the same. So I feel that I speak for thousands of families today who don't have a voice. When our loved ones die in custody, we're kept in the dark. We have no one to advocate for us, and no answers to endless questions. Records are withheld. Many times, the official narratives don't make sense or seem incomplete, or there's conflicting information. We're told records must be sealed because of ongoing investigations, or just because. The law enforcement agencies investigate themselves and find no wrongdoing. The district attorneys do the same, and often the oversight agencies in Texas, it's the Texas Rangers, do the same. No one even contacts the families again. And if they did, we wouldn't trust them anyway. That's what it's like to be in our shoes. So I'm very interested to hear what Farah has to say this morning as she talks about the progress that's been made in Austin. But I have 1,900, Josh. You said there's more than 3,000 law enforcement agencies. My Wikipedia information is not that great. Over 3,000, I'll go with that. Law enforcement agencies in the state of Texas, over 3,000. So I believe it is long past the time that we have a statewide oversight office staffed with civilians, not law enforcement, not prosecutors. An oversight office with authority to review records, police records, all the records, including the videos, and with authority to release those records to families and to the public, and authority to file criminal charges when that's appropriate. We need dashboard cameras and body cameras for every vehicle and every officer that has contact with citizens on the street. There is so much we need to do just to begin to bring transparency to policing in Texas. I'm thankful for the work that so many of you are doing. Josh and Kelly and so many others of you, and I'm just thankful for what's happening here today and all the work that's being done to promote transparency.
Well, and thank you for being here, and as you have, I know now for several years, and be willing to talk about this. So thank you both. Matt, let me ask you just from the perspective of the ACLU. You work on the legislative side, but in the off season, so to speak, when the legislature's not in session, I know you have a lot of interaction with law enforcement agencies, with transparency issues, how they deal with some of the statutes we're talking about. Tell us some of your thoughts.
Sure. We sort of deal with this exception in a few different ways, and I was going to talk about a few of them, but obviously the most relevant is a situation that was really similar to your situation, quite honestly. We had a couple of family members of somebody that was killed in an officer-involved shooting in Houston. And so two family members not from Houston approached us and had kind of the same idea that they weren't they were not even to the point of wanting to litigate. In fact, I think that this case in particular had basically been closed, and most people kind of agreed that the officers hadn't gotten in trouble, and there was not as much controversy around it. But this exception still did not allow these family members that, more than anything, just wanted to know kind of what their loved ones' last minutes of life were like. And so, we really, ultimately, it sort of has a happier ending. I mean, ultimately, Houston Police Department chose to allow them to view the video. But again, I mean, it was the same offer that you all received. I mean, these family members had to go to the police department, and it was sort of by the grace of the police department that they were able to see this video. But in that case, the family, I think, got kind of what they were hoping for out of it. And so I think, HPD deserves credit for kind of using their discretion that exists in a way that, helps family members come to peace with some of the things that happened. But I think it really, for us, was it really highlighted that it was only because we were able to get Chief Aceveto's sign off and others within the department that we were able to do this. And it was hard to imagine in every single instance where there's an officer involved shooting that a family would be able to put this kind of effort in and have the ACLU come in and everything else. And so, in our work, we see this exception having the same effect. I think, you all do speak for it. I just want to affirm what you said. I mean, you absolutely do speak for a lot of other families that run into the literal exact same problem. We also have a couple of other things, that this exception kind of brings challenges for us. Another instance in which there's a perpetually ongoing investigation or there is no closed case is when local officers turn someone over to ICE. From our perspective, we have grave concerns with inappropriate collaboration between local law enforcement staffed with our public safety and federal immigration enforcement officers that have a completely different mission and are constitutionally separated from the public safety protections that are provided by law enforcement. And so we have a real concern that if officers are working closely with the federal government, there could be constitutional rights violated, civil liberties violated. The easiest example is if you're pulled over and for whatever reason the local officer thinks that you might be undocumented and they kind of gin up reasons to hold you by the side of the road for an hour until ICE is able to come screen you and take you away. If that hypothetical situation were to happen, the videos are not available because there is no closed case. And so we have been investigating across the state as a result of the 2017 law passed by the legislature. We've been investigating ICE basically attempting to collaborate with local law enforcement and violating rights. And there are definitely a whole category of videos that are essentially not available to us unless discretion is used by law enforcement. In both these cases, in our favor, which has literally never happened on these kinds of cases. So, kind of from both of those, I think that there is a need for a change in these laws, and the decision point being held totally by law enforcement, whether it's with the body camera release or with this larger exception that applies to a lot more, law enforcement sort of has the final say, and I think that it really undermines the ability of journalists, of impacted people, and of advocates to provide the additional oversight. Farrah is going to speak, and she can talk a lot about how she has a role kind of as an institutional actor overseeing law enforcement, but I think it's very difficult to imagine our communities trusting law enforcement without this outside verification of advocacy organizations and journalists also reviewing what's happening and making sure that everybody's civil liberties and constitutional rights are being honored. I think we've lived through kind of the past few years, we've seen this. There is truly a lot of questions being raised about the justice within the criminal justice system. And I think at the ACLU, we want to be able to have the access to these recordings to show that, if there is justice, then people should be aware of that and realize that in some cases, officers are acting, I should say in some cases, very often, officers are acting well within the law and enacting the law or enforcing the law as they should. And when things go wrong, we absolutely have to have some way to correct that. And secrecy is no friend to needed reforms. The last couple items I want to just quickly go over. The first is that there's actually kind of an interesting future in question here. Releasing records is going to become important for kind of a reason that we haven't talked about yet. there are new technologies like automatic license plate readers, like facial recognition technology, and there are new programs. In particular, I've been thinking a lot about the suspicious activities reporting program. These programs, while offering kind of new frontiers in law enforcement, also raise kind of a host of new privacy and just, you know, freedom concerns, civil liberties concerns. And so public records being restricted or being kind of at the whim of law enforcement becomes an issue not just in individual cases and keeping accountable for when there's misconduct, but also in monitoring the kinds of enforcement efforts that are happening. So for example, DPS announced this week that they would be monitoring social media more heavily as a result of these mass shootings and gun violence. Well, you know, how do we get information as advocates, as citizens of Texas? How do we get information about how that's happening? Is it happening on permissible bases? So are people being monitored just because there's some indication of criminal behavior, or are people being monitored because of their association with a particular church or based on their free speech? It's clearly unconstitutional to monitor people based on constitutional acts. For example, going to a demonstration is a protected constitutional activity. Well, how do we know that DPS isn't violating our right to freely speak and to freely assemble unless we have some kind of ability to find out more about what they're doing? And that can mean not just like the rules that they're theoretically following, but also knowing what those investigations look like. And so the exceptions that we have now to law may in fact end up being even more important that we wrestle with them and handle them as technology grows. And then the last thing that I'll say is that, you know, I think that I had the honor of being a part of the body camera working group in the 85th legislature, I think, so 2017. And as a part of that, you know, I really got to hear kind of this robust conversation about all the different concerns and, you know, kind of goals for body cameras, particularly in the communities in our state. And I'll say, you know, I think my takeaway was that we're really early in this conversation. I think we have a lot more to learn, and we have a lot more policy to put in place. I think that a few of the things that we've done to try to protect privacy or to try to make sure that we're not, you know, that we don't have like different problems with the body camera footage, we've actually like greatly limited access to the public unnecessarily. And I think that the way that I think that this is evolving, and the way that I can kind of like give evidence that these are evolving laws is we went through the laws in other states, and you see a lot of the same trends. North Carolina, for example, has really tight restrictions on who can request body camera footage. And Texas also has these restrictions. Very often it's someone that's actually in the video, or perhaps somebody that is a representative of a person in the video. Very rarely is the public just allowed to request this body camera footage. While I understand the privacy issues involved, I think we should really consider whether that's an appropriate approach. We never limited dash cam release to the person who was the subject of the dash cam footage. Why would we apply these standards to the body cameras? Maybe we need a different brand of protections, but we're seeing it in other states. We'll see how it works in different places. Illinois has a limitation that only more serious incidents will be released. This is something that I think we've actually kind of ended up in that place in Austin. I don't want to step on what Farrah's going to talk about, but you know, in Austin, I think we've had a really productive conversation talking about when does the public get to see serious incident body camera footage or video generally. And I think we're starting to come to some agreement between the community members and law enforcement and the Office of Police Oversight. And then the last one is in Georgia, they used really similar privacy language in their law. So it was places where you have a reasonable expectation of privacy. To me, that's a really interesting frontier as we move forward in body camera, kind of what's releasable, what's not, what the public gets, what they don't. We have existing jurisprudence on what a reasonable expectation of privacy is. How do we bring that to bear? Rather than saying you can't have this video unless you're in it, how do we bring to bear existing standards of privacy so that people have kind of a way to predict what video would and would not be released to the public? And so, you know, this feels like the beginning of a path, not the end of any kind of road when it comes to the release of these videos. And I think that the technology, as it just moves forward and it gets better, will just raise more and more questions. And so, you know, I think as I let Farrah take over here, I'll just say that people like Farrah are going to have a really big job as technology just makes her job ever more difficult. So With that,
Thank you, Matt. And yes, Farrell, with that, fill us in on some of the efforts that you and the chief and others in the Austin Police Department have been doing on this issue of transparency, and specifically as technology evolves, and you have to handle questions of things like body cams and dash cams that in the 90s or whenever Chairman Hunter was talking about they didn't worry about. Tell us some things that are going on in your department.
Yeah, so I don't know how many of you have heard of the Office of Police Monitor. It was created in 2002 that was responsible for providing oversight over the Austin Police Department. The community pretty much came together and mobilized and demanded greater transparency and demanded greater oversight. And so a new office, the Office of Police Oversight, was created November 15th of 2018. And I've been leading the efforts of establishing this new office with a lot of community involvement. We redid our mission statement, and our mission statement composes of 3 parts. One is to provide impartial oversight over the conduct, policies, and practices of the Austin Police Department. Number 2 is to increase transparency. And number 3 is to establish sustainable partnerships with the community. So we're going to focus obviously on number 2, which is increasing transparency. This is a huge, huge issue. When I became the police monitor last year, I was really surprised about what we couldn't release to the public. And it put me in a very difficult spot because when people don't know what you're doing, they don't think you're doing anything at all. And we really weren't able to, the only thing we were able to make public was when an officer received a 1-day suspension or more. And that was really problematic. So as we entered negotiations with the Austin Police Department, transparency was foremost one of the key things that we were looking for expanding. So now we're able to post my recommendations, and the chief must respond. I'm able to post, make public my recommendations on discipline. When we get external complaints from the community, we can now make those public. I can now request through the city manager an independent investigation when an incident occurs. So we're really moving forward in terms of transparency and explaining to the public what we do, and that I firmly believe that public, that the ability to provide the public more information is another form of accountability on the police department. And so we have to get that information out there, and that's what I'm in the process of doing. And so right now, if you were to go to our website, it's atxpoliceoversight.gov, you will see we put disciplinary memos on. We're even changing the way we put the information out to the public. It used to be just a link and you click on it and read like a 20-page document. We're not doing that anymore. We're being very mindful and cognizant of how we give this information to the public. And within the next 30 days, you are going to see so much more information in terms of, because I think it's important that you see what's coming through our doors, what people are complaining about, and what people are bringing forth in terms of concerns, in terms of their interaction with the Austin Police Department. You are going to be seeing recommendations that we put forward. And so I think that is really, 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 really important toward transparency. But going specifically to this topic more specific to the topic that we're talking about right now, is the release of body cam video in a critical incident, and I'm going to focus primarily on officer-involved shootings. Every time there's an officer-involved shooting, I'm on the scene, and Chief Manley or whatever chief is there does a press conference at the scene. And that's pretty much where it ends, right? Literally. But we want more than that. The community wants more than that. And so I did a lot of research to find out what's going on across the state. And LA, who has a police force of, I believe, about 10,000 officers, they average about 30 officer-involved shootings a year. They have what's called a critical incident release policy. And they have a YouTube channel where they do what's called a community briefing, where they explain what happened to the incident. In the incident, I'm just going to use an officer-involved shooting as the example. And they're able to basically give you a briefing and walk you through what happened. And Matt has been a part of this process. It has, what I'm so proud of is that it is a collaborative effort between my office, the police department, and the community. And I feel very strongly that that's really kind of how we make change, particularly when the laws aren't necessarily with us. And sometimes the police department needs a nudge, but sometimes they don't. But here, we are working collaboratively to be proactive about putting information out that we know the public wants. And so our goal is to launch this new policy and the videos at the beginning of the year, and I think that's going to be really important in terms of enhanced transparency. One more thing I want to really mention, which I think is very important. In the prior iteration of oversight in Austin, when a complainant filed a complaint and it was resolved, they heard nothing. They got a letter from the office saying, your complaint is closed. Right? Which is crazy to me, right? Because you have to close the feedback loop. You have to give the complainant information about what happened, because these investigations take 6 months. We have a 6-month kind of statute of limitation for these types of cases. So now we're able to do closeout meetings, and I'm really excited. We just did our first one under under our new contract and new rules that we're going. We can give a complainant a full briefing. We can show them the video. We can talk about the investigative findings. They can choose to have internal affairs in this meeting if they want. They don't have to. But why I think this is important is we are a civilian office, right? And I am somebody who is very much imparted on my staff that we do our job with empathy, because these situations are very serious. We're dealing with people who have experienced, trauma, and have had negative experiences, so we have to be empathetic in the way that we go about it. And so our closeout meeting, though we anticipate it could be difficult because we have complainants who are seeing videos that they have never seen and never even potentially knew about, but even just that ability to do that is a step in the right direction. So I know we have more leaps and bounds to go, but you know how it is. You have to take every step. And so this step in terms of transparency is really important, and I really appreciate it that Austin is taking the lead on this, and I look forward for 2022, that's when we negotiate again, that we push it further.
Well, we'll invite you back to this session in 2022, and you can report on what you do that year. So, well, Farrah, thank you very much, and that update on the great work you're doing, and we'll look forward. It sounds like within the next 3 or 4 months to seeing some more, and also see how this may develop in other large departments or small departments across the state, because as Ms. Dyer said, that this is not something we do on a statewide basis, but rather on a department by department basis. A couple of things that I heard mentioned that I want to follow up on, and then invite any of the panelists who wish to comment to do so. Farrah, you mentioned when you first came to your job, you were almost startled by some of the things you can't release. And Ms. Dyer, I heard you say that in that first night you were there, or perhaps shortly after, you were surprised that certain information could not be made available to you as your son's mother. And generally speaking, at least with a few exceptions, but generally speaking, at least our State Public Information Act operates on the theory that if it's public for all. But conversely, if it's not public, it's not public for all. And the statute does have a provision, effective is essentially a waiver provision, that if a governmental agency voluntarily releases something which it could withhold under one of the discretionary exceptions, then it becomes public to anyone. One of the provisions that was included in the committee substitute to House Bill 147 that was mentioned in the first panel spoke to that. And it would have provided that a governmental body could release information to a family, information that might otherwise be eligible to be withheld, but could release it to a family member of a deceased or incapacitated person who is a subject of the information, and doing so would not be considered a waiver, so to speak, under that section of the law. So in other words, at least if a law enforcement agency chose to do so, would not require it under that section, but chose to do so, it could do so without then having the situation where it was public to the world at large. But any of you thoughts on that? As we heard in the first session, I think we can expect this issue to be back 2 years from now in Austin. But Josh, go ahead. Yeah.
I have strong concerns with that because while I do believe it is very important for family members to be able to see what happened in those situations, that does nothing to be open to the rest of the community. By giving journalists and communities and lawyers access to the same public information that they just wanted to make available to families, that does nothing to the trust of the larger community. If you have a systemic problem where something is happening over and over and over again, unless you see what is truly happening, how can you trust that police agency? And if you can't trust that police agency, then how can you ensure that the citizens are going to be following the laws of an agency that they don't trust? That's very important to me.
So in other words, your concern is not that that's bad per se, but that might be used as to make it easier to decline to disclose information to the public at large.
Correct. It just doesn't go far enough.
Yes, sir, Mr. Dyer.
I agree with Josh, very much so. In our instance, we're just regular folks. When something bad happens and they say, well, we'll only let one, I think the way that was written, that only one family member could come in and just view the videos. Not everybody has the expertise to know what they're looking at, nor in our instance, we were under extreme duress, and it would have been very difficult for us I would have done it, but it would be very difficult to see all the video, and it helps to have an arbitrator to know that the press, the freedom of the press, that, just Robert Lee Dyer cannot change anything because I'm just a little hillbilly up in Northeast Texas. But when we can open up the eyes of the rest of the world, and also to, when this first happened to us, we were just on a little island. And how many other people have experienced things just like this? How widespread is this kind of problem? When this first happened to Graham, and I told the district attorney this in Dallas, I said, we thought we were on the top of a big mountain. The most horrible thing happened to us, and it's never happened to anybody else. And I thought, golly, dang, that I just couldn't imagine that this is a commonplace. Boy, we found out, no, we're not the top of a mountaintop. We're just a little speck of sand on a beach of numerous. When this first happened to Graham and we started paying attention, there were just countless instances of where the police have done. And one more thing. As Mr. Watson said this, and I wholeheartedly agree with it. If the public business is conducted on a public device, it is public information. The language of this Public Information Act, if you read the preamble to it, is the most beautifully worded piece of writing that makes you proud to be an American. If we firmly adhere to this representative form of government, that it is of the people, by the people, and for the people, and we've created this instrument law enforcement, and it's much needed. But if this is an instrument that we have created, then we should be the masters of the instrument that we create, and our servants should not be the masters over us and decide for us what is good and what is not good for us to see. Y'all, I know there's a room full of lawyers. Sometimes it's all just words and clauses and things like that, but real people get impacted. Real people get impacted by these things. Sometimes we feel like we're just in a little chess game, but we'll keep playing.
Thank you. Let me ask, really any of you, although Matt, I may impose on you to take the lead because you're probably closer to the legislative process than some others. But we heard a little bit of the first session, but on this particular issue, what should we be looking for in the 2021 session? Will a House Bill 147 type bill have a chance next session? And Farrah, I might ask you from the perspective of a local department, are there changes either on this issue or just generally the issue of transparency that you would like to implement if the legislature would just pass a bill that lets you do it?
Well, I'll start, and I think I actually probably don't have, it's probably a relatively short story. You know, I think HB 147 is obviously an important bill concept, and I think there's no question it'll be back. It didn't feel like law enforcement had come around yet on some of these concepts, I think would be a nice way of saying it, maybe. Yes. And so I don't know how well it's going to do whole cloth. So that kind of leaves us with like, what do we do in the meantime until everybody comes around and we realize that this larger framework is a problem? I think there's two things. You know, number one, I do think that there's chipping away at it or taking pieces back is important. You know, I think that maybe looking at just the body cameras, and they have an even more restrictive, requirements and some other things. Maybe there's places to move there. Maybe there's a way to do some other little things that improve access. But I think the ultimate goal has to be to really look at some kind of a 147 type full-on change. Also, in the meantime, until we kind of get there, I think that local work can have a lot of success. You know, I talked a second ago, and I'm going to let Farrah talk more about this, but I talked a second ago about how discretion was used at the Houston Police Department to allow a family before the law changed a little bit to see this video. And I think that I've seen, really working with Farrah and with APD on these critical incident video issues, I've really seen the way that APD has utilized discretion that exists in the law, combined with kind of like a local expectations being put pen to paper. Here's how we expect things to go. In the first 60 days, we're going to do X. In the next 60 days, we'll do Y. Just because the state has left kind of just this broad question and law enforcement has total discretion on releasing because of this exception or this series of exceptions, it doesn't mean that at the community level we can't create expectations for law enforcement and when they would at least consider using the discretionary release option. And so I think that there's a lot of opportunity to, number one, start enacting things locally that just apply to one particular law enforcement agency as almost like a pilot program to see how things go. And number two, I feel absolutely, totally confident that there's not going to be a bunch of privacy problems or anything like that. I think we're so conservative in our release policies that we really I don't think we're going to get into like spoiling investigations or privacy issues. I think what we're going to see is in every case, when we do a pilot program where there's a little bit greater access, the public feels more trust, and there is not this issue with some of the concerned problems. And so I think what we need to do between now and the legislature truly addressing this kind of larger issue is develop local policies and programs that really illustrate that we've got a lot of room to release more of these videos and really just police records broadly. We've got a lot more space where it makes sense to do that, and we need to kind of have the state law line up with what will, I think, eventually start to be local policy on this. I think I don't want to speak for APD, but I think, for APD, that certainly there was a clamoring for what is the plan when, there's an officer involved shooting and you have the video, what are we going to do? Are we just never going to see it? And I think APD finally when they started engaging with the community on this question, they really took seriously the community's concern about this. And I think there's no reason that couldn't be modeled in a lot of other communities in Texas too. But anyway, Farrah, I'm going to let you talk about it. You're the expert.
Yeah, so I agree with Matt, but I would say but. The but is that at the end of the day, it's the chief of police decision. So fortunately, we have a positive relationship with APD and with the chain of command and with Chief Manley, and we've been working collaboratively together to advance transparency. And I appreciate that, of course. I mean, I think that that's great. But what if happens if you don't have that? What do you do then? Then you get no information? Then you can't push the needle? And so I'm going to milk the positive relationship for as long as I can, because I think it's great and I want more and more and more transparency. But I also want to be mindful of the reality, right? And so when I look at the body cam video, and particularly for the lawyers and the legislative people in the room, and I'm looking at law enforcement purpose, why does that not mean public transparency? Why is it so defined? Why is it narrowly defined? And so, to me, law enforcement purpose should include public trust and public information, and that's not really how it's interpreted. So, I'm a recovering lobbyist, so I've been taking a break from Illinois, and so I've been staying away from the legislature since I've been here in Austin for 3 years, so I may kind of revisit it in 2021 because I really want to see where this goes, particularly in the body cam statute. And I understand why, full discretion is given to the chief of police. I get it. But I do think we could nudge it a little bit to the middle for the sake of transparency. And so that's why I appreciate these conversations, but we're going to do with what we can now and in our collaborative fashion and with, the community putting pressure, and the community has definitely upped the expectation, not only for me, but for the police department. And so I think that there is a local component, but the but is still a factor we have to discuss.
Okay. Yeah, go ahead, Josh.
The thing that killed this measure was the law enforcement lobby. If this thing is going to pass next time, these conversations need to start a lot earlier than they did this past session. We wound up the clock till the very end, and there were a lot of conversations happened right at the very end of the session, and it just ran out of time. There is a way to pass this where all parties involved would be happier with it, where there would be transparency, but there would also be trust from law enforcement as well. I think that those conversations need to start happening as soon as the legislation is filed in November or December of next year.
In the bill pre-filing era.
Correct.
I do want to save a few minutes for questions, so let's do that. Yes, sir, right here on the front row.
I wrote about HB 147 and the problems with it, and the fact that it was going to be vetoed if it was included, as someone was said, in the bill. The problem with the bill was, from I'm guarded, and that's not for me to judge what in that score, but the problem was that the bill didn't just do that one thing. It also included access to law enforcement personnel records, and I interviewed the local court Joe, and he said, that's what the bill. And he personally admitted, I went to the governor and got this, and going to say that it would be legal if it was in there. And I think maybe the bill never made it, because then tried to provide access to law enforcement officers' prior records.
Yeah. So, and thank you for that. And again, just to follow up on the question and the comment. Besides this Section 108 issue we've been talking about, as he pointed out, that bill had some provisions dealing with access to officers' personnel files, and then that gets into, are you a civil service city or a regular city, whatever is the anonym of civil service, I don't know. But anyone, I mean, Farrah, you're the most likely to comment if you have a thought on that. I think the point of the question is, would it be easier politically to pass a bill just dealing with the 108 issue and leave others to a different bill?
Yeah, I mean, I'll just take it. If I'm using, my experience from lobbying in Illinois for 10 years, I would absolutely take it out. Even in my role, and I have access to pretty much everything, personnel records of officers is even still a little touchy for me, and I have access. So I would say, my approach to lobbying has been, to just make inroads where I can, and sometimes, I've been one of those people that filed the same bill over and over and over again until I was able to get it passed. You just kind of have to inch your way, but that is absolutely a poison pill. And I would recommend taking it out and focusing more on the access and the transparency. I don't know if you agree with that, but.
Well, I years ago gave up trying to dictate legislative strategy to legislators. I think we're here to give advice on what policy makes sense from our perspective. But I will say I agree with the tenor of y'all's comments that that this is maybe a heavier lift than the 108 fix. So you have the two different things. One's harder than the other. It doesn't always make sense to put those two things together. I guess just to briefly say why those things end up in the same package is that we don't want people using personnel files as a place to hide all misconduct either, right? And so you don't want to jump from the frying pan into the fire of secrecy in a different way. And I will say I don't know of an instance where this has truly happened yet, but you don't want to just create a new loophole. And so it's possible that trying to address the personnel files was an effort to get ahead of creating a new loophole. The other thing I'll say is that I think there are actually pretty compelling reasons that this is a slightly different from what you said, Farah, but I think that these personnel files can show a pattern of misconduct by officers, which I think is incredibly valuable public information. And so, yeah, I don't want to know if they got in trouble for something embarrassing, and that maybe there's a way to scrub some of that out of there, but I think a pattern of misconduct is the public's business. And so, again, I think that while as a lobbyist, I agree with what you all are saying, that we're talking about two different things, and one's way harder to do than the other. Why would we bind those things together? I can see from a policy perspective that, you don't, those personnel files are not this law enforcement is worried about those, but there's also there's legitimate privacy and, whatever employment reasons not to make those public. But there's also legitimate public interest in being aware of repeated misconduct. And so I don't think we're there on finding the balance. Maybe the answer is not so much to strip the part, but to come up with a version that better balances the needs of law enforcement with the public right to know.
If they're conducting official business, by golly.
I didn't even pay him to say that.
Well, I think it's all pertinent. If in the conduct of a police officer's business and they're dealing with the public, if they're past, if it's pertinent, then it's pertinent.
Can I tag on very briefly?
Go ahead, and then
Very
we'll
briefly.
have one last question. But you go ahead, Ms. Dyer, and then we'll get you over here. Ms. Dyer, go ahead.
I certainly think House Bill 147 would have satisfied me if it had been passed with some very simple language that I sent to the special committee, the combined committee that had the bill, to work out differences to House and Senate versions. I sent them an email. I wrote the damn bill to say, whatever it says in 108, except if someone dies in custody. Everywhere it says, if they're not incarcerated, if they're not deferred adjudication, except if they die in custody. Yeah. That would have suited me. I sent that recommendation, because I'm just like that. I'll do that.
Yes, sir, right here.
Isn't a big part of the problem is clean? Josh referred to it as the law enforcement problem. Robert, you mentioned that they had a representative in the emergency room.
Right at the gate.
With your son. And then everybody keeps referring to clean as being the lobby. But it's really much more than that. It's really a labor union for police officers. And you talk about why the chief cannot do this, or why he won't do that. That even corporations and even the cities over those police departments have to contend with CLEAT to get anything done, because it is much more than a lobby. It is a labor union that comes in and represents individual officers that may be investigated. And everybody, what frustrates me, who's been covering law enforcement for most of my career, is that everybody keeps referring to CLEAT as a lobby, and it's really much, much more than that.
And again, the question just for the audience, I'm guessing everybody here knows what that acronym is, but it's Combined Law Enforcement Association of Texas, an association, obviously, of police officers and other law enforcement employees. Anybody with a quick comment on,
They are
on the role of
much,
CLEAT?
they are much more than a lobby, but when you have multiple people coming before a committee to testify against a bill, that's lobbying against something. And when we have documentation of emails to the governor's office to say that this is a bad bill, then that's lobbying against something. So for this purpose, that's what they were doing.
But my point is that even people who may want to enforce police their own, such as a police chief, has, wayward officers in his ranks, his hands are tied because of the power of this labor union representing police officers.
Can I just give you an example?
Much more than just a lobby.
You're absolutely right, and let me give you several examples why you're absolutely right. When the contract expired between the City of Austin and the Austin Police Association, it was CLEAT and the Austin Police Association that sued the City of Austin, saying that the Office of Police Monitor could not operate. That was in February of 2018. Now, when an officer is under investigation and when Internal Affairs is conducting the investigation, they're being interviewed, there's a CLEAT representation in the room now. So the officer has a CLEAT representative and a union representative in the room. When we talk about negotiations, when we're at the table, the lead negotiator is from CLEAT. Okay, so you're spot on with that. It is a conglomerate of individuals who represent the interests of law enforcement. And you want to add something?
Well, the city of Austin was literally negotiating with CLEAT and
Yes.
APA for transparency
Right.
and police reform matters. Like, CLEAT was at the table. We were not. The advocates and community were not. I mean,
The lead negotiator was CLEAT. So your point is very well taken.
Yes. The title of this is Momentum,
Teaching science. Momentum is exactly what CLEAT has. It is a very, 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 I started out not knowing anything what it was, I just noticed, golly, there's this guy walking around with a CLEAT jacket. So, find out what CLEAT is. And I went to their website and all that, and it's amazing. And very much a lobbying, because there's, bills we're in favor of, bills we're not in favor of, and they have tremendous amounts of momentum. And, it's good for them, I guess, but.
Well, we could go all day on this, but hopefully we'll have some momentum in the other direction, thanks to the work
can I
of
address
the
CLEAT?
folks on this panel.
Can I say a
all right,
word about
We're going to
CLEAT?
give Kathy
Just-
Dyer the last word.
Just a word. I like to have the
Lots of
last word.
ways.
I'm kind of like that.
She says she kinda
I don't
likes that.
know as much as anybody else at the table, but I do know that CLEAT is very powerful. They are a lobby group. They're more than a lobby group. They're a union. They have power over police chiefs. They have power. And so I think that we, like people like me, like Robert, and like the others at the table, need to be talking with CLEAT and convince them somehow that transparency is a good thing for the officers that they represent. It is not a good thing when the citizens don't trust the police. We saw that in Dallas. It was a horrendous incident where 5 police officers were killed for who knows what reason. People, and I have a lot of young friends. Graham's friends are so kind, and many keep in touch with me. I have a lot of contacts with young people, and a lot of them don't trust the police. And that's not a good thing. That's not a healthy environment for the officers that CLEAT represents. They're not getting the services for their members that they need. Police suicide is a horrendous problem in this country. And that's just suicide. I wouldn't begin to guess, but how many officers, and there's so many thousands of them, that go home at night just a wreck from the incidents that they've had to deal with that day, and they're not getting the help they need. They're not getting the mental health services they need. They're not getting the rotations off of these difficult assignments that they need. There's so much that CLEAT could be doing if they really, truly cared about their officers.
Well, thank you, and help me thank all of our panelists for this great conversation.